Good morning, everyone. I, Samar Majid, moderator of Vasudev Law College, Nainital, Uttarakhand. I welcome you all to the 2 days national seminar on theme Law and Technology, the Future Prospects and Challenges in the Digitalized World. Giving a brief highlights of yesterday's proceeding. The session was inaugurated at 10 a.m. by Justice P.C. Pant, former judge of Supreme Court of India. The theme of seminar was introduced by keynote speaker, Dr. Preeti Saxena, Director, Center for Postgraduate Legal Studies, BBAU, Lucknow, and Dr. S.D. Sharma, former Dean and Head of SSJ Campus, Kumaon University, Faculty of Law. Then, plenary session at 12 noon. The panel was comprised of Dr. S.D. Sharma, former Dean and Head, and Mr. Aditya Singh, Advocate of High Court, Uttarakhand and Supreme Court. Then, technical session was conducted under chairmanship of S.D. Sharma and was co-chaired by session Dr. Sudhir Kumar Chaturvedi, Assistant Professor, Faculty of Law, HNBGU, Tehri Campus. Before introducing the chair, I would read the rules of this online session and theme. The online presentation rules. Number 1, the presenters are required to mark their attendance in the chat box only by mentioning their names, designation, institution, and paper title. Second, the presenter will be cancelled according to, the presenter will be called according to already shared list in the group. Thirdly, presenters are required to keep their mics on mute at all the time except their presentation or asked to do so. Fourth, the presenters has been allowed for 4 minutes for their presentation. A warning bell will be rang at 3 minutes and the mic will be automatically turned mute at the completion of allotted time. Fifth point is, the resource person are requested to put their queries at the end of presentation. Thank you so much. I would like to introduce the guest, Dr. Kalpesh Kumar L. Gupta, founder, Pro Bono India, legal startup, Law Teacher India, Real Estate Law India, former associate, IIM Ahmedabad, former faculty of JNLU, Gandhinagar, startup mentor and social entrepreneur, the Law Teacher India. Our next guest is Dr. Nidhi Saxena, Assistant Professor, Department of Law, Sikkim University. Our third guest is Mr. Veer Mayank, Dr. Veer Mayank, MPhil from JNU, and area of specialization, international trade and business law, international law, and international economics law. And last guest is Dr. Shivani Singh. Ma'am is currently assistant professor in Amity, and earlier she was in IGNO and teaching experience for 4 years. Thank you.
I would like to invite Hemant Kumar, Raj Rishi Bharti, Matsya University, Rajasthan.
Hello. A very good morning to all the participants and panelists. My name is Hemant Kumar, and I'm a research scholar in Matsya University. First, we'll know what data is and what is the need for the data protection and the historical background of data protection laws in India, how this emerged. Then we'll also discuss the key provisions of the DPDP Act, which is Digital Personal Data Protection Act 2023, and then the issues that the Act faces. And at the same time, we'll also have a comparative analysis with the GDPR of European Union of the provisions of the DPDP Act. So, beginning with, first we'll focus on what the data is and what is the need for the data protection. Data is any information, but the DPDP Act focuses primarily on data. To the applicability of the Act, then we'll come to know that the act is applicable only the data in digital form. It applies either it applies to the personal data if it is in digital form, or if it is not in digital form, if it is in offline form, then it is converted to the digital form later. Okay. At the same it applies to the data processing within India. At the same time, it applies to the data processing outside India also. If the objective of the data processing outside India is providing services and goods in India. So basically, if we go to the applicability of the Act, then it applies to the data processing within India if it is collected in digital form, or if it is collected other than digital form, but later converted to the digital form. Also, it applies to the data processing which is done outside India if the objective of data processing is providing services or goods in India. If we go to the historical background of data protection laws in India, since we are surrounded with the digital world, and data is always there, which needs protection for the confidentiality thing and for preventing identity theft. So we need a data protection law in India, before 2023, there was no comprehensive data protection law. So, if we go to the chronological order, how the data protection law in India developed, then first step, the first landmark thing is Section 43A in IT Act. In IT Act 2000, it was added by 2008 amendment, and this was the first step towards the data protection in India. And then the IT amendment rules 2011 were added, and then the landmark judgment of Supreme Court in KS Puttaswamy versus Union of India came. As a result, the Shri Krishnam Committee was founded. Shri Krishnam Committee was founded under the chair of Justice Shri Krishna, and finally, after the Shri Krishna Committee's report, Ministry of Electronics and IT introduced Personal Data Protection Bill 2019 in Parliament, which which was referred to the Joint Parliamentary Committee, and it couldn't turn into an act as it faced quite decent from the stakeholders. Finally, a fresh bill of the data protection in November 2022 was introduced, which again could not be passed. Finally, the current law, which we are talking about today, is Digital Personal Data Protection Act 2023, which was introduced in Lok Sabha in August. At this, it was passed in Rajya Sabha on 9th August and received the assent of the president on 11th August. And finally, it became an act, though it has not yet come into force. It is yet to come into force. And as I have discussed the applicability of the act, I would like to move on the key provisions of the Digital Personal Data Protection Act.
I would like to invite Archana, Mahatma Gandhi Central University, Bihar.
Good morning, everyone. I am Archana, PhD scholar, Mahatma Gandhi Central University, Motihari. मेरा टाइटल है कंज्यूमर प्रोटेक्शन इन द ई-कॉमर्स. Consumers are one of the major components of business system. The consumers are persons who use the goods and services offered by the business players. The protection of the rights of the consumers is also important for the betterment of the commercial world. With the advent of the internet and World Wide Web, there was an expansion of traditional commercial activities into the electronic platform. People are becoming more attached towards online shopping. The e-commercial activities have become the most important and happening activities which is taking place in the cyberspace. Many e-commercial activities take place in the cyberspace. The e-commerce platform had enabled the Indian consumers to cross the boundaries of states and enjoy the products of their choice. The increasing number of activities taking place in the e-commerce alarms about the protection of online consumers and their interests. So when it happens in the form of business to consumer, the interest of the consumers need to be protected. Like in the physical commercial activities, there are also consumers buying or availing goods or services for a price. In India, the numbers of consumers engaging in online shopping is increasing. This alarms us about the protection of consumers' interests and their rights in the digital era. But there are many challenges to the protection of the consumer interests in the online medium. Lack of paper legal provisions is one of the most important among them. In India, we have Consumer Protection Act 1986 and Information Technology Act 2000, which basically deals with consumer protection and electronic commerce. The consumer can initiate proceeding against the seller of service provider whenever there is a defect in the goods or deficiency of services. Whether the consumer includes e-consumers and same remedy is available for them as well. Since the electronic commerce has wider presence, is the current law is sufficient enough to deal the various aspects. Though the consumers can file a complaint under the existing law, the system of disposal becomes difficulties task. In related Consumer Protection Act 1986, Information Technology Act 2000, Consumer Protection Bill 2015, with the fast developing technology, the e-commerce has made its presence in our daily life. So the e-commerce industry is not equivalent to the physical retail market. The population involved in it is increasing, not diminishing. Consumers are also facing many challenges due to a lack of proper remedial mechanism for e-commerce industry, especially with respect to online retail industry. So consumers of e-market have to be more caution and follow the maximum caveat emptor while entering into e-commerce market for business.
Presenters, if have any resource persons, if have any queries, you can ask by unmuting the mics.
Okay, let me ask one question. Archana, what's your critical thought about this? Critics, I need critics. You just stated, some provisions. Archana, what's your critics on your, this title and work? Over to you.
Archana ma'am, please unmute yourself. Due to some technical problems, Archana ma'am is not coming with us. So we'll start with next presenter.
I would like to invite Jaswinder Singh, Maharaja Agrasen University.
Good morning, everyone. So my topic is decoding legal dimensions, the legal analysis, smart contracts. So I'll set the tone as it say. Don't miss the introduction, please. I'll set it in my own words now.
Please,
To
sir, kindly
explain
open
smart
your camera.
contracts, I'll just refer to an example. Everyday example. Yes. To start with the example, I'll start with the example of a vending machine, which we all find in these installed in the theaters and malls, where these cold drink bottles, the water bottles, certain chips and other things are dispensed when you put in money. So it takes in coins via simple mechanism, dispenses change, which by change I mean the currency and product according to the displayed price. The vending machine performs two critical functions. It effectuates the performance by receiving money. Of money, they pool in money. Let's say 30 ladies, they pool in money, and of money, they pool in money. Let's say 30 ladies, they pool in money, and every month a raffle is held, a draw is held, and one lady is handed over that 30 collective amount collected from 30 ladies. Now all these 30 ladies has the administrative control. Everybody can reconcile the entries. They can make the entries. But the reconciliation is according to a protocol setup wherein every participant of the Excel sheet, administrative participant of the Excel sheet has to reconcile the entry as per the protocol. So the ledger is maintained. They're basically they're like technical ledgers, I would say. Blockchain is nothing but a ledger, hyper technical ledger. So moving on to the top, they can simplify the international transactions such as shipping goods by automating the execution of terms and conditions. The decentralized consensus ensures universal acceptance of transaction details recorded automatically in a distributed database. Despite their functional clarity, questions persist about whether a legal framework is necessary for smart contracts, considering potential issues like fraud, mistakes, or contract formation. Now, the technical contracts, how they come into being? If somebody, I mean, programming is basically what is a contract? There are conditions in a contract. In an additional contract, there are the conditions that if this like there has to be an agreement, an offer, acceptance of an offer. So how offer and acceptance of an offer in a way. So I think I need to conclude it really well. The only thing is that when the programming parlance, it comes on the basis of logic, which is if there is logic, if a condition is met, then the result will happen, which is collateral to an offer and acceptance of an offer, which fluctuates into a contract. Now, the issues which the time I think muted many questions. I mean, the judges may the resource persons. I mean, your questions are most humbly invited.
To remain this side. If I have got the
Yes, sir.
permission of the organizers, may I go ahead and ask a couple of these are not
Of course,
questions,
sir.
these
Yes, sir.
are just uh, these are not questions, these are say my doubts or maybe some clarifications that I may need.
Yes, sir.
See, we are talking about the blockchain and smart contracts.
Yes, sir.
Now, smart contracts, blockchain, as you have already mentioned, is based on a ledger technology, Byzantine cryptography, etc., all that stuff. But see, right now, what kind of a blockchain you are visualizing means, we do not have a kind of a permanent blockchain. Bitcoin was there. There are, I think, 19,000 blockchains right now in existence.
Yes, sir.
How are you
Yes,
going
sir.
to put up a smart contract on one of these blockchains? Who is going to devise this blockchain? Means we come onto a legal platform. We try to find out what.
Absolutely, sir. Absolutely. An online portal at London, your credit card is swiped at Nainital, right? Through your financial institution, whatever your financial. So that how come that reconciliation is done? I mean, within minutes you reconcile, you make the payment, and the product is in your kitty. No doubt it'll take some time to the time to deliver the product, but that is not the domain of which you've asked. Now you are concerned about is that yes, the transaction is how that the whole universe of the financial transactions of the world, how do they reconcile? This is what blockchain is all about. And what are the smart contracts? The contract between you and your financial institute, the contract of the financial institute to the central, I mean, the central reconciliation system of India. Then this contract is like say third instance. The thing that world is suffering today is that Bitcoin is the payments are free of the Amazon kitty to sell. There are just three products. At once I get a thing that only two are left. So we already on this. The only difficulty in understanding the thing, of course, I mean, things like I mean these guys. I will be very. I mean, right now I'm in states just for. I've come specifically for this purpose to just conduct my research because my research also area for my research is also the same. So now here there are three states have already given a stamp, a statutory stamp to the companies who are running on blockchains. They are being considered as corporations incorporated under the Companies Act of the states because here the system is states have more autonomy than our states. We have a federal structure, which is that to say that we are not on a blockchain and we are shying away from it, like that. That to say that we are not on a blockchain and we are shying away from it, like that's I will say we are just trying to close our eyes to the fact which is arriving. I hope I've been able to explain, sir. I mean, the best I could
I
in
mean, thank you for your wonderful comments
and much
or maybe
obliged,
your
sir. Much obliged,
explanations.
sir.
But see, my question wasn't that actually.
Yes, sir.
My question wasn't really. See, I have explained a whole lot of things about the blockchain. My question was pretty simple. See, the longest blockchain is the most what do you call the most genuine kind of a blockchain, which on which we have to rely upon. Means the shorter blockchains are ignored. So now you're talking about smart contracts, and then I think when you're talking about the smart contracts, you're talking in a global context. So how are we going to ensure that which blockchain is going to be the longest? Means of a legal mechanism will you want? You
See,
cannot
that's
just
I'll come
confine
to
it
it
to
as well.
India.
I'll come. Yes.
Okay,
See, there are
okay,
three things,
that's
sir.
it. Yeah.
So I'll take an example. See, there are three kinds of blockchains. That is because let's not compare. I will not expand on it, though I can. I can go off for like few minutes, but like time is short. Everybody is to participate here. So it's like this. There are two kinds of blockchains. One is the blockchain which is like when you're talking about a long blockchain. Like I understand there has to be much computing potential in it. For computing potential, you need machines. For machines, you need I mean, much of electricity. But then we have to understand if the otherwise the securely look if you're talking about like one, if I have to get my blockchain designed for my office purposes only, so that's I don't need to go on the bigger network. The company who's already doing it, I'm not able to just know the names, the commercial names, Ethereum, etc., etc., etc. That has not been my domain of my research, the company thing. But there are companies available in the world who can do it for your college itself. Like the blockchain would be designed for you guys, like your alumni can have this thing. I mean, you can imagine a thing that how much work you have to get, to what extent the work and the optimal work has to be extracted. It depends upon you. It's not just that you are put on to they say forcefully they'll say no this thing only is to sell you can put it on no the this thing it will be designed to your need which will of course take into consideration the everything the energy cost and everything. This is the best I can explain the technical power of it, though I can go on with the technical things but I don't know about the companies but they do it actually. One is
Thank you
like the
so much,
global
sir.
thing which is like the financial systems, of course the
Thank you so
Bitcoin.
much. Sir, I would like to introduce our guest who is physically present with us, Mr. Rajiv Dubey, Assistant Professor at Vasudev Law College, Nainital, Uttarakhand.
So just to carry on the entire proceeding, I'll request kindly take the other name who is supposed to present the paper.
I
Because
invite Anshika Singh Phani and Deepak Mamialavalli, Vellore Institute of Technology.
yes, please.
I would like to invite Anshika Singh Phani, Deepak Mamialavalli, Vellore Institute of Technology. She is there. Anshika Singh ji is there. Move on to the next kindly. Muskan Dr. Archana Shehrawat, MIT University.
Okay, very good morning to all the people present over here. I'm just sharing my screen. Yeah, I hope so. It is visible to everyone now. Yes, so my topic of research is cyber forensics in India, a legal perspective. As I have a shortage of time, so I'll be straight away jumping towards the perfect portion, that is cyber forensics and cybercrime. So cyber forensics refers to the examination of an electronic evidence by way of applying technological tools. And cybercrime refers to all those crimes that are conducted with the help of internet along with the electronic gadget that can be smartphone or laptop or computer. Now, when we are combining both of them, at the end of the day, we have some electronic evidences that are produced in the court to support a particular case where the examination of the evidence is done by the forensic experts in the forensic labs, where ballistics, all of these are applied over there. What my research area included was, first of all, the laws that are present in the IT Act 2000, which is discussing about the act of cyber terrorism, then publishes which I am currently referring to the child pornography over here. Then I have studied section number 67, that is child pornography. Sorry, yeah. And then the last section that I related in my study was the act of cyber stalking, along with the IPC section. Okay, so the problem that I faced during, or I must say the hypothesis that I was having in my mind was that the cyber forensics area in India isn't that much developed as much it should be. Why? Because the NCRB report says that there has been a rise in the uh, cybercrime. However, the conviction rate has remained low. The reason behind this, there are two key reasons. First of all, we are not able to examine the electronic evidences correctly, properly. For example, the first stage starts right from the collection of the evidences from the crime area. Whenever the cyber forensic experts are called for the upliftment of the electronic evidences, there are instances when even the evidence is not uplifted in the correct form, which somehow hampers the justice road. And the key reason is, if you're not able, for example, if I take the best example, while I was sitting, one of the key cases was the computer had to be detached up from the crime place, and then the entire system was to be submitted to the forensic lab. However, while detaching the computer, it got damaged, and the result was, because of the damage suffered to the electronic evidence, there was a complete problem while extracting the evidence from that device. And the second problem that I concluded from that particular case law only was, even though the evidence was extracted, somehow they had to again make a copy, and then they had to store that one real copy, and then they had to represent the another that was a duplicate copy. So by presenting the duplicate copy, the forensic expert was not updated, which led to the loss of the evidence. And the third reason was, because of the cyber forensics area, there are a lot of crimes that are committed by the cyber criminals. So with the correct exact knowledge, because of which the judge had to conclude that without having the complete knowledge of the evidence, the experts advice cannot be cited. So the two problems that we are facing over here is one, the lack of knowledge, and another, if we take the note of the authorities, then I must say that it is the government suggestion that we are failing to. Okay, just giving my suggestion and conclusions from our own portion, that is from the side of forensic experts. We must be updated with the knowledge, and from the side of the government, the suggestion would be that proper funds must be allocated, proper labs must be formulated, so that there is no delay in the justice.
I invite
Okay, I hope
Satakshi
so.
Tripathi. I would like to invite Satakshi Tripathi, HNLU, Madhya Pradesh.
Good morning, panel. Thank you for the opportunity. A little correction, it is HNLU Raipur. Okay. The topic that I've chosen for presentation is human rights convergence with law and technology, and the special emphasis is on UNCLAUSE. So basically, when the plenipotentiaries met and the second conference failed to achieve the universal ratification, and with the success of almost a universal convention in 1982, we had a we had a global principle established by the name of Common Heritage of Mankind, which was coined up by the Maltese ambassador Arvid Padro during a UN GA speech in 1952. So the concept says all the nations globally who have ratified UNCLOS document will be free to conduct any research, exploration, or exploration in the deep sea bed, which will initiate after 200 nautical miles. That is the highest. So, the glitch point in this almost universal convention is because of the technology transfer aspect. US did not sign it, and till date, in the contemporary scenario, US is one of the major developed nations who is not a signatory of the UNCLOS convention. The main theme is when this term exploration and exploitation was coined up in the conjecture with common heritage of mankind, the basic proportions and perspectives of technology, the equipments, the amount allocation by the ESA, which is the International Seabed Authority, and the pioneering states along with the investment companies, they all delve deeper into the aspects of technology. And the conclusion was US was not ready to sign the document because they were then under, if they had signed it, they were under the obligation of sharing the technology transfer details to other developing nations, which was unacceptable at that point of time. And therefore, we said the seabed mining thing, the seabed mining procedure is not yet practiced of full scale because of some loopholes, basically some loopholes which are relevant, and this is all because of the technological aspects which are involved in the seabed mining. So even the ESA, along with India, for instance, India started its flagship project in 2021 along with ISRO, which is called Matsya 600 is the mission Samudrayan, which is for the digging up of polymetallic nodules from the seabed. So that will include again. Had the developed nations or the global north would have been more open about technology transfer, it would have been easier for the developing nations along with the underdeveloped nations to involve in such practices. Therefore, I would conclude that technology holds the very basic. Uh, it's the prerequisite of any convention, be it ITO, the International Telecommunication, or the International Aviation Communications, or the any other domain, the municipal law, it definitely includes the technological aspects. And for that, I think it is much contemplation is required when states and plenipotentiaries meet and discuss about.
Thank you,
I think
Sitali
time's
ma'am.
up.
I would like to invite Aditya Karswara, Dr. Neeraj Malik, NIMS University, Rajasthan, Chamu Ram Law.
Hello.
Yes, ma'am, you are audible.
Hello. Everyone. Today I want to present my paper on rising trend of cybercrime in India, a contemporary analysis. Without wasting the time, if come for introduction, India has great society into information society by applying digital India paradigm. Their government sector, the private sector, and the individual completely depend on the internet to conduct sensitive transaction and store important data. This make India into cybercrime is a criminal activity that either target or just a computer network or a networked device. Most but not all cybercrime is committed by cybercriminals or hackers who want to make cybercrimes is by an individual or organization. Cybercriminals are organized, use advanced and are highly skilled. Others are novice hackers. Rarely, cyber psychological crime. Presently, it is observed that there is highly complex cyber criminal network. So, next, next topic which I want to discuss is types of cyber crime. There are definitely different type of crime which are as follow: phishing scam. Phishing scam are attempts by scammers to trick you into giving out your personal information such as bank account number, password, and credit card numbers. These scammers will contact you out of the blue via email, text message, phone call, or even through social media, pretending to be a legitimate business such as your bank, telephone company, or even an internet provider. The scammers may ask you to update them on your deal so that they can refresh their system. They may even ask you to fill out a survey as you have the chance to win a prize. There is some prevention which use a full service internet security suite, use a strong password, and strengthen your home network. Finally, I want to conclude that internet is a very powerful tool and effective means of communication, but it is a vulnerable just like anything else. There are must be a
Due to some technologies. I would like to invite Prashant Kumar and Dr. Anjali Dikshit.
You can proceed, sir.
Yes, yes. Uh, yes. Thank you so much. So my topic is the role of public prosecutor in the digital era, a discourse from legal perspective. So starting from the IT Act, the development of information technology has always been a revolutionary effect on all commercial sector. and the legal field is not immune from this. In the recent in the recent era, we see that the has transformed the into a digital system because more of the council could not be able to appear physically, either the party or the council itself. In such system, the Honorable Supreme Court has developed a system wherein they have introduced a system that party can either appear themselves in physical mode or through digital mode. So these are the things that we have seen in the in the recent. Now coming about the various type of cyber crime and what the role that the a public prosecutor or government counsel has to play in it. So what we have seen that due to the development of information technology, various cyber crimes has been erupted. In such situation, the public prosecutor has to be mastered upon that how to produce the for the public prosecutor during this digital era to produce all those electronic evidence and to appreciate the evidence during the trial is very difficult prosecutor working in in this digital era. I would also like to highlight the government, the court initiative that recently what we have seen that all those accused which has been put before the PG can be produced through digital mode through internet, and that helps in and that helps the court to run smoothly, and that also helps to sort out the problem that is being that is being taken by the government in that regard. So, in my humble submission, I think that there need to be a proper sensitization program for police officers for proper investigation, also for the government council like public prosecutor and another government council, so that the criminal trial can be run smoothly and in a fair trial manner. Thank you so much.
Thank you so much, sir. Dr. Nidhi Saxena, ma'am, will you like to conclude something?
Actually, her network is not working. So just let me try to ask her.
Any questions? Any queries you can ask?
I would like to invite Dr. Bijaya Das, Apex Professional University. I would like to invite Dr. Bijaya Das, Apex Professional University.
Good morning, everyone. Am I audible?
Yes, ma'am, you are audible.
Hello. Is my presentation is showing sharing?
Yes, yes, ma'am. You are visible.
Okay. Uh, okay. Uh, Good morning, everyone. Myself Vijay Das. Today I'm going to talk about the topic legislative framework of cyber stalking in India. First of all, I would like to talk about the meaning of cyber stalking. So cyber stalking means when someone, by utilizing the internet and other telecommunication technologies, harass or threaten someone, which may disrupt that person's life and make them feel afraid and in danger. So my presentation talks about two things: to identify the legislative framework of cyber stalking in India. Next, to analyze the loopholes of the legislation relating to cyber stalking in India. Before that, I'd like to highlight some factors which is responsible for cyber stalking in India, like jealousy, obsession and desire, erotomania. It is a delusion where a person falsely believes that someone is deeply or obsessively in love with him. Then sexual harassment, revenge, and The
Excuse me, ma'am. Will you
the
please
legislative framework of
explain third
cyberstalking
point
in
once
India.
again?
Yes,
Please explain the third point one again.
yes. Third point,
Yes.
or that is erotomania.
Yes.
Okay, erotomania, that is a delusion where a person falsely believes that someone is deeply or obsessively in love with him. Next, I'd like to talk about the legislative framework of cyberstalking in India. There are no direct legislation which deals with this type of crime, but we have two legislation, that is Information Technology Act 2000 and the Criminal Law Amendment Act 2013, which not specifically, but they deals with such type of crime. First one, the Information Technology Act 2000. Here we have 5 provisions, Section 66A, which deals with delivering offensive material via communication services. Then Section 67, which deals with publishing or sending offensive or pornographic information in electronic form. Then Section 67A, which deals with material containing sexual explicit conduct. Next, Section 67B, which talk about the stalkers that target minors under 18 years. The last one, Section 66E, which deals with willfully or knowingly violates another person's privacy. Next, we have the legislation, the Criminal Law Amendment Act 2013. Here we have 5 provisions from IPC, that is Section 354D, which talks about the definition of stalking. So the definition of stalking, it's talk that the persistently following, contacting, or making an effort to speak with someone despite their clear indication of disinterest, even monitoring someone's electronic communication like internet, email, etc., which cause fear, disturbance, or distress. It can be called as stalking. Next, we have Section 292 of IPC, obscenity. Then we have Section 507 of IPC, that criminal intimidation by anonymous communication. Next, we have Section 509 IPC, which violations of women's privacy. Then Section 354C, which talk about the seize or record a woman engaging in a private act without her consent, is also a punishable offense. Next, the next slide, I would like to say about the loopholes of legislation relating to cyber stalking in India. So the most of the provisions which I have discussed are women-centric, and cyber stalking is not only a crime against women. So the victim can be both men and women. So an universal provision is required to deal with such types of crime. Next, I would like to say about the complaint mechanism. That if you are a victim of cyber stalking, then you can complain through this mechanism. We have four mechanism till now. The cyber cell, you can complain to the cyber cell in your place, but if you doesn't have cyber cell, then you can go to the local police station and give an FIR. Next, we have complaint to National Commission for Women, then report to the website, that particular website from where information is leaked. Next, report to the SART. SART, that is the Indian Computer Emergency Response Team. You can complain through the website of SART team, then email them, then through the telephone and fax, and through the postal address. So that's all. Is my presentation is over. If you have any question, you can ask me.
Now, I would like to welcome and introduce our guest who is physically present with us, Dr. A.K. Naveen, sir, who is working as professor and director in the School of Law in Uttarakhand, Open University. Sir, some words for us.
थैंक यू। ये अभी ये ऑनलाइन चल रहा है, तो ऑनलाइन प्रतिभाग करने वाले समस्त प्रतिभागियों को और यहाँ ऑफलाइन मोड में जो प्रतिभागी आए हैं विभिन्न राज्यों से या लोकल जो भी हैं, मैं उनको इस सेमिनार की बधाई देता हूँ। मैं उम्मीद करता हूँ कि सेमिनार के अंतर्गत जो भी रिकमेंडेशंस आएंगी उसको जो है प्रोसीडिंग्स में लाया जाएगा। और ज़्यादा अभी तो मैं कुछ नहीं कहूँगा। मैं पुनः आप सभी प्रतिभागियों को और ख़ास करके जो इस सेमिनार को ऑर्गेनाइज किए हैं तमाम जो है ख़ास करके चंद्रशेखर जी या उनकी टीम को बधाई देता हूँ कि ये सेमिनार जो है अपने चरमोत्कर्ष पर है और सकुशल संपन्न होगा। थैंक यू।
Thank you, sir. I would like to felicitate Dr. A.K. Naveen sir, and here Dubey sir is with us. I would like to call Dr. Gaurav Gupta sir to please give felicitation to Naveen sir.
I would like to invite Dr. Vasudev Roy, Jalpaiguri Law University.
I have just observation for Bejia Das before a next presentation presenter comes. Can I ask the question or give my observation?
Yes,
Yes,
ma'am.
ma'am.
Okay, thank you so much. Actually, Bejia, you have mentioned the one section 66A of Information Technology Act as provision for cyber stalking, or you can say provision against the cyber stalking. I wanted to just check this provision because in the this was struck down by the Supreme Court. Is
Sorry, ma'am.
Sorry, ma'am, please
Sorry, ma'am.
repeat the
Your
question.
voice is not clear.
Ma'am, please repeat the question, please. Ma'am, please repeat the question. Am I audible, ma'am? Some technical issues, sorry.
hello, hello.
Yes, ma'am.
Yeah, some
Ma'am, you
technical
can
issues are there. I'm
inbox in the
using
chat
the
box.
so just 6A, kindly check this section. This is held unconstitutional by the Supreme Court in Shreya single case. You cannot mention section 66A as a provision. As a provision, you must be aware that when the
Yes, ma'am.
Supreme
Yes, ma'am. Yes, ma'am.
Court is so just that.
Yes, ma'am. Yes, ma'am. I forgot to tell that in 2015, that share single case, this section 66A is removed. Sorry for that, ma'am.
It has no relevance. Oh, it's fine. Just wanted to give you this observation. Thank you so much.
Thank you, ma'am.
I'm so sorry. I'm continuously facing some network issues. I'm using Dr. Veerman's uh, platform for communicating this. Okay, thank you.
Now, I would like to request respected Dr. Veer Mayank, sir, sitting in my resource personal panel to increase our knowledge by giving their statements regarding the theme and sub-themes of the seminar. Thank you, sir.
Hello. Hello, am I audible?
Yes, sir, you are audible.
Hello.
Dr. Veer Mayank, sir,
Actually, I
sitting in
just
my resource personal panel to
yeah,
increase our knowledge.
I didn't get you. What I actually your voice was breaking. So
Okay,
can you
sir.
repeat again, please?
Sir, I request you to increase my knowledge by giving the statement regarding the theme and sub-theme of our seminar.
Okay, thank you, ma'am. Thank you
Thank you
for
so much.
giving me the opportunity.
Yes, sir.
It's not my call increase your knowledge means we are all in the same boat. And what I believe is that we all help each other to uh, grow forward
Yes, sir.
by enhancing each other's knowledge. So anyway, thank you for again for giving me the opportunity and helping me to increase my knowledge through these deliberations that you have very kindly organized. I've been working on a couple of areas, and one of them was this blockchain, Bitcoin. Of course, Bitcoin is a part of this blockchain subset, maybe we can say. Second area of means my specialization is trade and economic laws, including financial laws, and of course, then the framework becomes the international law. So, what I heard from one of the participants about the blockchain and smart contracts, he was particularly focusing on smart contracts. And then there were a couple of lectures on cyber security. Two things that I could see or I could point out in these two themes. Regarding cybersecurity, what I want to say is that say what I understand with cybersecurity is more of a conflict between anonymity and identifiability. When we are on a cybersecurity platform, then we are actually looking at anonymity. Means once we get onto the internet, we try to be anonymous as if cyber stalking or cyber crimes take place due to anonymity, then what we are seeing is that we need identifiability of the person concerned so that we can uh, prosecute him and convict him. Now, this goes against the very tenet of internet anonymity. So, first of all, we will have to find out what kind of balance we need between anonymity and identifiability. Cyber crime means whoever is sitting behind a computer screen is no longer, you don't really know me. Who am I right now? I could be just about anyone. My face is not visible. And even if it was visible, maybe the deepfake technologies would come up later on and confound all the participants with who is talking to whom. So anyway, that's the question between identifiability and anonymity. That's what we are facing at this level in as a legal problem that we are facing. Second thing, what I want to uh, present my opinion. It's not means again. I'm not sharing knowledge. We are basically increasing each other's knowledge. So regarding blockchain and Bitcoin, we have got these three big technologies that are coming up. Blockchain, and that's related to the libertarian model of governance. Second is your, of course, the AI, which is right now becoming quite famous or infamous for different reasons. And the third, of course, is data mining and big data. Data mining and big data is a bit old. AI is coming up, and blockchain is going to be the technology of the future as far as governance models. That's what my opinion is. Now, when we talk about blockchain, Indian government is not, as of now, what I feel is that Indian government is not as much interested as it should be in blockchain. We have got the digital rupee, but we do not have a cryptocurrency that was earlier proposed. It was Lakshmi. And similarly, cryptocurrencies have been proposed by other countries also, like in the case of China, they had this cryptocurrency, crypto yuan or something like that, but it really didn't work out. So basically, when we start talking about cryptocurrencies and we talk about blockchains, the presenter very rightly had pointed out, to my understanding, that cryptocurrency can be confined to an institution, even confined to a family, even confined to means cryptocurrency has got a huge flexibility. Oh, sorry, blockchain has got a huge flexibility. But then what smart contracts, when we talk about the smart contracts, they are not really, we cannot really confine them. When we talk about a physical contract, that's on a piece of paper with a signature on that, a public cryptographic address, and a signature which is a private key. Now, if we are going to confine blockchain to, let's say, a company, then we cannot really build up a smart contract on that. So first of all, we will have to determine what kind of a governance model we need. And blockchain governance model is cannot be confined by borders. That's the huge problem with regard to cryptocurrency and blockchain. What is the governance model that we are going to adopt? But anyway, what I hear, the views that you have expressed, wonderful seminar on such important topics. With this, I would like to uh, thank you and Dr. Gaurav for giving me this opportunity. Thanks a lot to all of you, and thanks a lot to the organizers. Thank you.
Thank you, sir. Now I would request respected sir, some questions are there. One student has a doubt she wants to ask. I'm passing the mic.
Hello, am I audible?
Yeah, to me, you are audible.
Okay, first of all, a very good morning to all. So my question is related to blockchain. That what in means what is the future expectancy of using blockchain uh, in order for it to be favorable in the people in general? Like we've understood that blockchain stores like through blockchain we can store enormous amount of data, and in future also we can uh, I think it's all about enhancing the technology, and we are moving towards technology as far as we like I hope with the crux of it you're getting the crux of it. So the blockchain, I'm very much interested in the blockchain technology, so and its regulations. So can you please highlight certain points regarding it?
Thank you.
Aliza, my name is Aliza.
See, blockchain technology try to means uh, let's say let's put it in this fashion. You have got a flexibility, of course, in blockchain that you can make it as large as possible or as small as possible. That's fine. What blockchain does is that it takes away the present governance model that is there for governing a society. It's more of a libertarian model. Means I should not be confined.
I would like to invite Jaswinder Singh, Maharaja Agrasen University. We asked a question.
Yeah, no, it's not a question. If I may supplement the answer, I think we lost Sir, Mr. Mayank, we lost him. See, if I can answer the lady's question, like I can answer it, and if I'm allowed to answer it.
Yes, you are allowed, sir. Sir,
So
brief
listen
answer. Sir,
to it.
brief
Let's
answer.
not, I mean, yeah, it's going to be a very brief answer. So let's not get overwhelmed by the fact that blockchain is a new technology. So you take blockchain as an operating system, and it is just an operating medium for commerces to run. How do I explain it? See, I mean, I explained it earlier also. It is the participants who are running, I mean, running a system, running a program or an enterprise on a blockchain based model. They all have control over it. I'll explain you something. let's say you are, I mean, you want to log into your, I mean, this thing, the college's website. First of all, a login has to be created by an administrator for you here. And if you are on a blockchain, nobody needs to give you an access about it. You already have an access. You can manipulate the data. It's not, I mean, in a wrong way. Manipulation means that you can, I mean, do the data. I mean, you can take it as a positive manipulation, you know. But that, I mean, changing of the data, I mean, changing manipulation of the data has to be reconciled as per the rules set up by your university. It could be the admission process, like you are, I mean, one of the participants who is, I mean, interested in getting it to one of the participants, like 10 participants who are responsible for the admission committee. You don't need a single administrator. All 10 of you will be the administrators. You will be admitting students as per the seats available in the respective courses. And once you admit a student, that information will go to all the other 9 participants that yes, if this course has 50 admissions available, you made the first admission, then only 49 are available. So this is blockchain is, you have to, it is not an operating system, but you have to take it as a Windows operating system, the medium on which different programs run, you know. Your app, like it's an Android system, and Android many applications
Thank you,
run. The
sir.
basic, yeah.
Thank you, sir.
I would like to invite Dr. Vasudev Roy, Jalpaiguri Law University.
Am I audible?
Sir, you are audible.
Thank you so much. Good afternoon, or good morning, rather. Myself, Vasudev Rai from Jalpaiguri Law College. First of all, I want to thank
Sir,
Vasudev Law
please
College
switch
for.
on your cameras.
Yes,
Please switch on your camera.
yes, sure.
Thank you.
So, am I visible?
Yes, sir. Sir, you are visible.
Okay, thank you so much. First of all, I would like to thank Vasudev Law College for organizing this seminar. And today, my topic is artificial intelligence and employment crisis, a myth or a reality. So, today I'll discuss here that is it a myth that we are facing that artificial intelligence will take over human beings, like human employment. So here today I would like to highlight some points. First point is that is artificial intelligence. Second point, that is machine learning. Third point, that is human loop or human in the loop. And the fourth point, that is AI education. And you can say that skill gap or skill AI reskilling, rather. Okay. Then the last one, that is employment polarization. So first of all, artificial intelligence, that is very few, we have very few knowledge that means we came to know about the artificial intelligence when it means not in the good way, but in the bad way, rather. That is that when the students or the people started using a chat gpt for not for positive sense or positive purpose. And like we nowadays we came to know or came across about the deep fake technology. Okay, so these are the things that means we have to means check. So first of all, artificial intelligence, that can be mainly of two types, that is normal narrow artificial intelligence or general artificial intelligence, or another one, that is generative artificial intelligence. So first of all, that is will not talk here about the narrow artificial intelligence. That is a very basic thing that we use in our mobiles or computers. Okay, so generative artificial intelligence, that is important, and that is the thing we have to develop very carefully, that is generative intelligence. So in generative intelligence, that is one thing we have to understand, that is machine learning. So how the machine works, and how by machine learning we can just collaborate with the machine or computer. So this is the first thing, that is we should have the knowledge about the computers or computing systems. Okay, so this is the second point. And the third point, that is the human loop. So this is the a very important point, or the gap, you can say, that is human loop or human in the loop. Means that where the artificial, how the artificial intelligence works. Like artificial intelligence till now, so means till now the artificial intelligence does not means take over us, like so artificial intelligence need human assistance. So where we have to work on that. So by artificial, so autonomous artificial intelligence is not, still is not there, like so it needs the human involvement. So that is human involvement we have to take care about. That is the human loop or human in the loop. That is the, without the human assistance, the artificial intelligence, till now the artificial intelligence cannot work itself. So this is the thing we have to take care about. And that fourth point, that is the I already discussed, that is AI education. So in India, or in India, so in no college, especially in no school that talk taught means teach about the artificial intelligence. So artificial, so this is very important, that we have to have the knowledge about artificial intelligence. So if the government introduce such policies, like means introducing artificial intelligence in schools, so it will be easier for the human being to understand artificial intelligence in better way. So, and the last one, that is skill gap and skill development. So, and with this I will discuss that employment polarization. So skill gap, so this is, or this is a myth or not. So artificial, definitely artificial intelligence will take over some human labor, but the thing is that if we educate ourselves to, or reskilling ourselves to, about the artificial intelligence, and we thus keep holding the command over artificial intelligence, so it will be very easy for us to regulate the artificial intelligence in a better way. And the last thing, that is polarization. So if we don't have, or means that grip on artificial intelligence, so definitely some people will definitely use the artificial intelligence for their own purpose, or for making benefits. So this is the thing. And last one that I would like to suggest, that to cope up with this, all these problems. So that number one, that is hybrid work model. So in hybrid work model, we can work with the artificial intelligence, means assisting artificial intelligence, and artificial intelligence will take assist from us. And the number two, that is artificial human being and artificial intelligence collaboration. So that is also a good this idea to collaborate with the artificial intelligence. And number three, that is reskilling. So we have to reskill ourselves to that
Thank you,
we
sir.
can have that grip over artificial intelligence. Thank you so much. This is my
Thank you, sir.
presentation.
Thank you for adding our knowledge.
So if there
Since
is any
all our
question,
participants till now have presented their paper, now I would request my resource person, Dr. Kalpesh Gupta sir, sitting in my resource person panel, to increase our knowledge by giving their statement regarding the theme and sub-theme of this seminar. So welcome.
Yeah, thank you very much to organizer Gaurav Gupta and all the team members for inviting me. So okay, I'll be focusing on what I've been doing for last few years, working on the legal aid part, and how the access to justice, and like the technology can help me access to justice and legal aid things. So I'll be sharing a brief PPT that I prepared for your let me share the PPT, and then you can. One second. I hope it's visible.
So it's loading. Yes, sir, it's visible.
Yeah, thank you very much. So you can see, like, I hope everybody, I'm not going to discuss, legal aid and then it in detail, but again, how the legal tech and the innovation can help to enhance the performance of the legal aid access to justice to meet the objective access to justice. Now, you can say, like, we have, the people are worried about this legal aid, the kind of legal aid work we can do, what are the issues and challenges. and what more can be done in legal aid. Again, not going to the detail. We know we have Article 39A, and then various other provisions, and then in various laws are there related to access to justice and legal aid. Now again, we see always not like we consider always the going on the field. It's a part of legal aid, not necessary. You can have a legal advice, awareness, paralysis, or do something work on the related to legal reform. That is also part of legal aid. Now, see, like why law students should involve themselves. Obviously, faculty supported by and guided by faculty members. You see, the students will learn these things because the practical thing that you learn by dealing with the legal aid, the problems that come while being in the connection with the legal aid and the legal aid cell in your college or maybe with any other NGO also. So you learn practical skill, you learn enhance your professional responsibility, and then it's a great platform for learning. Again, you can see a lot of things are there. There's a history how it started legally, various committees were there, and then later we got this RA 39A, and then the various committee, and then this Legal Services Authority Act is there. Now, this is the hierarchy. I hope most of you must be aware about NALSA, SALSA. This is the structure of this thing. Again, the conventional way the legal things are going on. So more issues you can see, like we need practical thing in the legal education, and then some other constraints are also there, budget constraints, and then so again, and then conducting legal aid activities at our wherever we are in law school or maybe in other area part of any country. Now you see the way forward, what you can do, the more and more practical things can be added in our legal curriculum, whatever subject we are teaching. Again, the last part you can see that we need innovation in the legal aid activities. Right. So again, I'm not going to other detail like related to legal aid. So related to tech part, how because we are not able to reach, like obviously not possible to reach and provide legal aid to every corner of the country. So in that case, you will see this innovation part. You can see these are some initiative. I'm working in legal startups area for last few years. So these are the things like with the help of initiative by law student and any other, not necessarily the law student, by anybody interested in the providing the platform, and then some kind of some the technology element or LNGs are there. So you can see like for the platform called Samviti and Project Sati. These are the again my student from Gujarat National Law University. They initiated in last few years. So for awareness, some are doing very good work, groundwork. Some are also file the PIL in high courts also. So these are the ways how they started initiative with the different objective and approach. Now you see again like in COVID time, like everybody's worried about their obviously own health, how to cope up with and it's not possible to do legal aid activities. Again, like I hope must be aware about the scheme called Telilo Nyayabandhu. We discuss in a couple of minutes. So this is a way like Department of Justice. They approach us, and they ask for, because the panel law, they used to get around 50 to 60 call in a day, and they were in requirement of some of the volunteers interns. So I requested the interns, they were doing internship under me. So in that case, under the Pro Bono India, so in that case we facilitated this online orientation were there, and then we made a four group, and they assisted the panel law all over the India in working, dealing with a variety of cases and other matters. So this is like how law school they help in the COVID time, like a digital whatever the platform was available. Again, one of the you can see students see like started this from GNL student, again alumni. So related to a lot of issues were what are our rights, and the things were there. So she started this platform covidrightsindia.com for the awareness of this thing, and I also approached her related to interviews there. You will check it out. Now again, the how assistance can be provided in this thing in the COVID times, like what happens in a crisis. So that was again what initiated by students, how law school they collaborated related to this thing. Again, labor issues was also there. So National NLU Bhopal, they initiated this action. Now related to, you see, this is a platform I started putting. So things related to legal aid, one platform doing research and conducting variety of activities. And recently we conducted fourth edition of online course on legal aid and allied laws. In that, one of the topic was there on cyber laws, like technological, how we can help, because these are again we are each and everyone, I would say, they are connected with the technology. I would say more 90% of the citizen in India, I would say maybe we can no discount 10% of people. They are connected with the cyber law, technology, other things, and how we can help them. And there are a lot of issues and challenges are there. So we also included that thing on our that one of the topic in the legal aid course, how we can make ourselves aware and how we can help people to using the technology and what are the pros and cons should be there. Now, like related to telelaw, I don't know how many are aware about this thing. Again, last 2 3 years, we can see a lot of campaign has been going on. Actually, they started in 2017, and last 2 3 years because of the campaign, they got people got to know there is a pre-litigation advice and reaching to people all over the India. You can say this is the way like work. You can consult a doctor. Sorry, like we can consult doctor, right, with a very appointed. Same thing, the appointment is done with the the panel lawyer. You go into like the common service center, we can call it a computer center, and again set up by initiated by the government of India. That way you can have the benefits of and then consult with the panel lawyers. You can see the chart how it works. The PLV is a paralegal volunteer registration case, and the beneficiary visit common service center. Again, the local layman language computer center, you will get the legal advice. Sometimes some small advice really helps you, right? You have when you are clueless, not necessarily you'll go for litigation only, but this kind of advice will help you. And then again, it was now there's no Section 12 was there like related to who are eligible for to get the legal aid. Again, now it's free. Anybody can approach the common service center around your area and get the free legal, advice. Now, obviously, it's crossed the 59 recently. Again, 58 lakh people, and obviously recently crossed 59 lakhs of beneficiaries with the Telelo. So, this is again great achievement of this. And then next to Nyabandhu, you can see here, this is the app. So this is launched in 2019. So as an advocate also, you can get registered with this app and beneficiary also. They try to make as as easy as possible how we can get benefit from this. Again, challenges are there. How to make them aware about this initiative and make life easy. So in legal aid also recently we also invited one of the state coordinator, the working tele law. So he explained that there is because now I think who a person who is using the mobile phone can easily do this kind of thing, downloading app and the usage of that particular app. Even if there is a question by a couple of participants, sir, if anybody is not having smartphone, so what should be there? It's not like, for example, you, right, we as a resource as a citizen or anyone, right, we can register case for themselves, right? Obviously that you can put their mobile number who are need of a legal aid, and so it's a possible. It's not necessary I am having the smartphone I will get this kind of benefit. No, also you can register those cases and then on behalf of other person, and so then things can be operated still. You can see many have seen advocates. So sometimes registration problem is also there, tech issues are also there, not able to register. Sometimes you're not getting cases also even if you are registered. So again, this is a thing I would say appreciate. It was something happening in the legal aid and the access to justice. So this is a tech part. So this is the how the app was. You can just check it out, this thing. And then pro bono legal services, again they started with the help of law schools also. Nyabandhu, this app. So there's a DISA scheme is there, designing innovative solution, holistic justice to access to justice. DISA scheme by Department of Justice. So in that say they initiated this telelaw, Nyayabandhu, and pro bono club and the legal literacy thing. So you can just check it out how technology helping and reaching to people who are not able to get access to justice. Again, this is a helpline number you can see. Sometimes you check, there are helpline number are also there, online applications. But again, we are not able to reach. We have experience. People are from Delhi. Sir, I guide them. There will be helpline number is there. Sir, nobody's picking up the phone or this issues are there. So how it can be resolved? It's not. It should not be like automatic. Okay, like handling of the phone. Some person should be there and guide uh, whatever person are need. So again, recently the new helpline started. So practical thing, online. So many platform like app is there, online websites are there, helpline are there. But how it works when working, that's a cause of concern for us. Different initiative you can see, innovative part working on the project 39 NLU Delhi. They're working on related to access to justice, legal aid. This is report for the online trial. Recently, I hope some of us be aware about the Smart India Hackathon. In that, they ask for the innovative things, for example, like tech-based solution for under trials. that was one of the problem statement given by the in the Smart India hackathon. So how technology can help legally under trial business, and various other 5 6 more in that particular problem statement initiated given by the Department of Justice. And other, I would say, not again necessary in the legal aid, but again the other, like for the Ministry of Women and Child, they also put some the problem statements. So also you can and obviously date is over. So many the students from engineering, they approached me, and they are working on, they obviously would have submitted their idea to the Smart India hackathon. This is an initiative done by law schools, GNLU, for the conducting various legal aid activities, symposiums. So you can present your idea, and then again this is a competition of legal aid by NLS Bangalore. So this is the things happening out of box in legal aid area. How technology can help to people to reach out the masses in different way. So this is the, again, obviously issues and concerns are there. How we can resolve those issues with your the acumen, your initiative. So thank you very much. This was some input from myself. Over to you.
Thank you, sir. Such valuable words you shared with us. Our next participant.
I would like to invite R. Vimla, VELS, Institute of Science and Technology.
Yes, ma'am.
Ma'am, please open your camera.
Ma'am, I'm facing some network issues. I'm currently at my
Okay.
native place.
No issue, ma'am.
Okay, 1 minute. I'll share my screen. Ma'am, is my screen visible?
Yes, ma'am, your screen is visible.
Okay. Good afternoon, everybody present here. Myself, R. Vimala. My paper is about a study on bioplastics as a sustainable alternative to plastics. So, the main objectives of my paper is to know whether bioplastics serve as a sustainable alternative that we could use instead of conventional plastics, and to find out if the government encourages the extensive use of bioplastics, and to analyze if bioplastics can be adopted in our day-to-day routine, to study PLA plastics as a sustainable alternative, to identify the factors that prevent the use of bioplastics. So, to start off, I conducted my survey with the use of questionnaires, and I gave them around the area of mother of oil and collected a few data from the general public, and based on that, I have made my research. Okay, 1 minute. So, the major problem that exists in our current society is the plastic pollution. So, it has become a very big problem, which is harming marine life, ecosystems, and human health as well. These The main problem with plastics are that they take hundreds of years to decompose if they lie on the surface of the earth, which contribute to long lasting pollution, which poses as a threat to biodiversity. So my aim is to uh, investigate about a sustainable alternative that we could use instead of these, which is less harmful to the environment. So the concept of bioplastics are a solution as they are derived from renewable resources, which is made from plants or microorganisms. And they have the potential to reduce our dependency on fossil fuels, which help lower carbon emission and overcome a lot of environmental challenges and make our world a safe place to live. The study explores the viability of bioplastics in mitigating the adverse effects of plastic pollution to create an environmentally friendly future. So basically, bioplastics are made from microbial fermentation or plant-based materials. Their biodegradable their biodegradability and compostability are the key features which make them an attractive alternative or option, and it's easily disposable, which causes less pollution to the environment as well. The types of bioplastics are PLA, known as polylactic acid, which is made from corn or sugar cane, and PHA, polyhydroxyl notes, which are produced through microbial fermentation. These can be used in various industries, from packaging of consumer goods to medical and agricultural sectors, as they are very versatile and sustainable as well. So based on my survey, I was able to list out the benefits and costs. The benefits are that they are renewable, and which reduces the use of our fossil fuels, and this also reduces the environmental impact, which contributes to a circular economy. Bioplastics have reduced carbon footprint, would generate fewer greenhouse gas emissions. And their biodegradability allows for natural decomposition, which is helpful to humans and microorganisms as well. The costs are that it's a big challenge to segregate a particular
Thank you, ma'am.
economic amount.
Because of time constraints, so we have to call for the second another participant. And
Okay, thank you.
Hello, ma'am. Can I present, ma'am?
Nazrul Islam sir is there.
Yes, ma'am.
So you can proceed.
Okay, ma'am.
Thank you.
So, my paper title is From Policies to Practice, Investigating the Real World Implication on Human Rights. So, begin with introduction. Women land rights have gained significant attention in recent years as a crucial aspect of gender equality and women empowerment. The recognition and protection of women land rights are not only fundamental human rights but are also essential for social and economic development. In many parts of the world, including India, women face various barriers and discriminatory practices that limit their access to and control over land resources. India, being a diverse country with a complex social fabric, has made significant strides in enhancing laws and policies to address gender disparities in land ownership and rights. The state of West Bengal, in particular, has implemented progressive legislation and policies to promote women land rights. However, the translation of these policies into effective practices remains a challenge. Birhum district, located in West Bengal, provides an interesting case study for exploring the real-world implication of human land rights. This is characterized by a predominant rural population where agriculture plays a significant role in the economy. My research objective is to analyze the existing policies and legal frameworks pertaining to human land rights in rural areas of Birhum district in West Bengal. Second, to examine the implementation and enforcement of human land rights at the grassroots level of the Birhum district. Methodology. My primary data will be collected through a combination of methods including interviews, focus group discussion, and surveys. Review of national and state level policies on human land rights. National level policies. The Constitution of India guarantees equal rights to men and women, including the rights to own and inherit property. However, customary laws and deep-rooted patriarchal norms have limited the realization of these rights for women. Hindu Succession Act 1956 brought significant reforms to granting daughters equal rights in ancestral property. However, implementation challenges and societal bias still persist. State-level policies, West Bengal and Land Reforms Act 1955. This act aimed to redistribute land to landless farmers and provide security of land tenure. It recognized women's rights to agricultural land but often faces challenges in implementation due to social norms and administrative issues. West Bengal Panchayat Act 2003. This act mandates 33% reservation for women in local self-government bodies, while it provides an average for women participation in decision-making process related to land. Its effectiveness varies across different regions. Examination of specific laws and regulations related to land ownership and inheritance in Bihar district. Land ownership laws. This act aimed to bring about agrarian reforms by regulating land ownership tenancy and land distribution. It introduced the concept of Operation Border, which granted rights to sharecroppers. However, the act doesn't explicitly address gender disparities in land ownership. Identification of various challenges faced by implementation of enforcement process, lack of awareness and information, limited knowledge among rural women about their land rights and entitlements, insufficient discrimination of information regarding relevant laws and policies, inadequate outreach program and awareness campaign by government agencies and NGOs, sociocultural norms and gender inequality, deep-rooted patriarchal attitudes and norms that would prioritize male inheritance and land ownership, discriminatory societal practices that restrict women access to and control over land, resistance from male family members and community leaders in recognizing and accepting women's land rights, land and administrative challenges, complex and legal procedures for transferring land titles to women, lack of effective implementation mechanism for enforcing women's land rights, inadequate capacity and resources within government institutions responsible for land administration. Findings and land ownership patterns. The analysis revealed that a significant gender disparities exist in land ownership in rural areas of Bihar district. Women have limited access to control over land, with the majority of land being owned and controlled by male household members. Only a small percentage of women in the
Thank
in
you,
the
sir.
village that.
Thank you, sir, for sharing your knowledge.
Thank you, ma'am.
Now, I would request Dr. Nidhi Saxena, ma'am, sitting in my resource person panel, to increase our knowledge by giving her statements regarding the themes and sub-themes of seminar. Ma'am?
Thank you so much for inviting me.
Thank you,
A
ma'am.
very good afternoon
Welcome.
to all of you. First of all, I would like to appreciate the organizer for picking up such an important issue, and I find all the papers were relevant here in the presentation. I would like to share my PPT because I am just picking one area that I believe is not yet shared. So just allow me to share my PPT. I hope the PPT is visible to everyone.
Not yet, ma'am. Now it is visible. Thank you, ma'am.
Okay, I think just give me a minute. Yeah, I hope. Is it visible now?
Yes, ma'am. Visible.
Thank you so much. So very good afternoon to all of you. The PPT is actually going to cover the three main aspects that I wanted to bring in the notice. That is the issues of data localization and its relation with right to privacy and the theory of free flow of data. Uh, in today's era, in 21st century, we all are experiencing the emerging technologies. We have smartphones, we are using different devices that actually tells the power or potential of technology. So we these technologies are producing enormous data, and yes, the technology that we are using, like the artificial intelligence, advanced analytics that are mostly used by the business people, or even the cloud computing, these things can be cited right now as an example of potential embryonic technologies. So even the Internet of Things produces a vast amount of data which can then even serve as a base for other technologies. So data is regarded as the new source of power. I have two theories right now that I wanted to discuss. I will try to confine my presentation within 10 minutes as I'm asked, but a little about these two theories that I wanted to discuss with you is one theory that believes in the free flow of data, and then there comes the theory that says not all data flows should be treated the same. I mean, there are two theories. One theory is saying that the data should be